Divorce is often one of life's most challenging experiences, emotionally, legally, and financially. But it doesn't have to feel so overwhelming. Welcome to the Smarter Divorce podcast, where legal expertise meets financial insight, empowering you to make informed decisions every step of the way.
Hi, everybody. Welcome to the Smarter Divorce podcast. I am Jane McAuliffe. I'm a certified divorce financial analyst, and I do divorce financial planning and divorce mediation alongside my co-host, Kari Rafinelli, who is a divorce attorney here in Rhode Island. Together, we work as a team to tackle both financial and legal questions that people have as they navigate through either the divorce or the mediation process. And today is episode 3, and we are going to be talking about the anatomy of a case and maybe some of the do's and don'ts as you embark on this process. And today we have our awesome colleague and collaborator, Victoria Lombardi. She's a partner at Asselone and Lombardi here in Rhode Island, and we work on a regular basis with her and all the partners of her firm as well on various cases and various projects. Welcome, Victoria.
Thank you, Jane. Thank you so much for having me. And Kari, happy to be here.
Good to see you.
All right, so today we're going to be talking about a couple of different concepts today. People normally want to know, Kari, take it away. What's your opening line? People want to know.
Well, when people come in, they want to know how long it's going to take, how much is it going to cost, and how I'm going to make out, also known as winning.
Exactly. So we're going to touch upon, how long, how much, and are they going to win? And we're going to talk about the 3 major areas of divorce, and those are your asset and debt division, the custody and placement of your children, and support, meaning child support and or spousal support if that's applicable to your case. So we're going to break down those top 3 compartments of what is involved in a divorce or a mediation. We're going to talk about some of the issues that might either help speed up the process of your case or actually slow it down quite a bit. And Victoria and Kari have incredible insight because they've worked for many years on both, collaborative cases, mediated cases, but also on the high conflict side of things. So they're going to share with you their knowledge, some stories from the battlegrounds to help people get a perspective of what they might face or come to expect as they proceed through this process. As you know, every divorce is a fingerprint, Victoria and Kari, and you can't really tell a client when they come into your office like what to expect, right? Because there's so many different factors that are applicable to their specific circumstances. But today, where should we begin? Some of the complicated factors that happen in asset division. Since that's my area of where I spend most of my time. Maybe we'll start there today. Does that sound good?
Yeah, absolutely.
Sure. All right.
Well, and I'm so glad that you've brought up that every divorce is a fingerprint, because I'm so frequently telling my clients, right? I equate it for my clients with children. A divorce is like a birth of a child, right? Everybody has a story of how their birth went, right? And process and the complications that went through it. And just because your Aunt Mary may have had one experience does not mean that that's going to be your experience. And divorce really is very much akin to that. And so I'm glad that you've started off with that, because that's the biggest thing for anybody going through this process to know and, quite frankly, accept.
Exactly. That's perfect. I would say, from a divorce attorney's standpoint, and even in the process of mediation, if you don't know or are unfamiliar with the process of both a regular traditional litigated divorce and mediation, we did cover this in episode 1 of our podcast earlier, which you can go back and review. But I guess when people come into your office and you're talking about asset division, what are some of the things that your clients bring up right at the start? Is it, protecting assets while they're going through the process? Is it, how do I get prepared? How do I start to get in the know? I guess, what are your clients' burning questions at that point in time as you're starting to talk about that?
So for me, the biggest question is always, what do I do to prepare and how can I protect myself, right? People, when they're starting the process, it's normally of how do I best situate myself? And Kari and I are very familiar, and Jane, you as well, with that when a divorce gets filed, there are automatic orders that enter, right? And those are the initial protective orders. I joke and say it's like a hands up, everybody freeze, don't make any drastic changes, don't start changing beneficiaries, nobody's liquidating accounts, right? It's meant to keep everything status quo. That is ideally what happens. As Kari and I know, that doesn't always happen, right? And so the court has the ability to punish those who act wrong. Players are going to play whether you want them to or not. And there are some mechanisms to spool things back if somebody is acting out of line. But really, the court wants things to stay as is until we get a handle on them. I mean,
Right.
Kari, what have you found?
Every client wants to know if they can run to the bank and take all of the money, and the answer obviously is no, even if you're contemplating the divorce. And in any event, those that are fearful of this that we're addressing in this podcast should know that the court can recapture that. Records tell the story. So even if 50,000 was taken out, 100,000 was taken out, this is Jane's specialty as well as tracing back those assets. But if all goes well, and we stress mediation, but if all goes well, everyone is on the level playing field. Both are informed not to do that kind of activity. And in any event, it's like a speed control device. It's going to be seen. It's going to be tracked back. It's going to be recaptured, and it's going to be accounted for. For those that take it, they'll just get that much less from their side of the column. And the court's cognizant of that. And as Victoria said, those are why the automatic orders exist.
Right. And to your point, Kari, right? If money walks away at the start of a divorce, if it can be walked back in, it either is or it's held in a special account, typically with either one of the attorneys that is
Right.
protected, and monies are not released unless there's court orders. But if, there's truly the worst case scenario where that money is gone, as Kari suggested, the courts will typically say a credit gets to come back and that will be counted towards the innocent spouse. So, I mean, there are mechanisms if the worst case scenario is to occur, but most people try to avoid that because nobody wants to be the individual who plays funny with the money in front of a judge thereafter.
And the positive side of that is for those eligible cases is advances of money to each equally, so they have the money for mediation fees or they have the money for attorneys. If all goes well, both people will put their heads together, save their money, and allocate it equally towards their resources, as opposed to running to the bank, raiding it, taking it out, and spending thousands of dollars on attorney's fees just to recapture it.
Truly.
One thing to add is normally I'm working with the out spouse, the person who has not really been involved in the financial picture or management of day-to-day bills or have any control over the money. I mean, I run the gamut with that. I have people who are in charge and making all the decisions, and then I have some who are like completely in the dark, living on a stipend from their spouse with no access to any joint accounts. So in those circumstances, I mean, we try to flesh that through in mediation right off the bat, to give people the ability to start managing their own assets and making good decisions and making sure that it's fair and equitable. But when you have clients come in that scenario, what are the steps that you take?
So, I mean, I follow a pretty typical formula in my office in that, you come in, the divorce gets filed, we get that process started. The very next step in that process is the filing of and the issuing of discovery, right? And discovery is exactly that. It's a formalized process where we request documentation from the other side. They provide it within a certain time frame. Typically, requests are made of us, and we give it back. And that is the opening up the hand of poker, saying, here's everything, here's how it exists, here's how it lays, and getting that clear sense of what everybody has. So the spouses that do come in that have no idea, have never been involved, those that have wanted to be involved and cut out versus those that have, said, I don't want to know, don't tell me. There's that process that they get to open up the books, take a close look. And depending on the complexity, that's where, we have formed a deep love for Jane in our office of when things start to move rapidly and numbers are going in and out and there's some evasive maneuvering happening, that Jane can help us with that accounting and figuring out what really lays and exists. And The end goal of that discovery process is to identify are assets marital in nature, subject to division, non-marital, or maybe a portion premarital, and how that's going to affect what we actually divide out.
Yeah, I agree. There's some complicating factors there. I mean, we try to approach that the same way in mediation, right? So whether I'm working on a litigated case, I will often help attorneys figure out what to request as well. Given a basic asset profile, not all the time, not as we all know, not everybody's an open book and just giving all the statements that are requested, right? There's sometimes withhold information, sometimes they give partial information. So part of my role in this is to figure out, okay, do we have everything we need to review? Do we have enough time frame of documents to review? Um, and we try to attack that the same way in mediation.
Right. And I mean, as you talked about too, there's this of unwillingness sometimes. So yes, we do this formalized process that the judge oversees to kind of help us facilitate, get what we need to do those calculations. But there are tools out there, right? There's subpoena powers, there's deposition powers, there's all of these other things that exist that
Yeah,
if, a spouse is difficult, we can pull them back in. And I will say,
exactly.
as part of a contested divorce process, the discovery process can feel like one of the longest, most tedious elements if somebody is being evasive. And so that can take a large chunk of time. We say it very nicely to say, oh, yeah, they have, 40 days to get it back to us, but it can go 5, 6, 7 months.
Yeah,
And the court will give them the ability to do that, right? Whereas in a more friendly mediation session, right, if people come documents in hand, ready to have that discussion up front, it's again a huge time saver, energy saver, emotion saver on all of those things and kind of makes them their own masters of their universe, so to say.
yeah. Yeah, and we do that right from the beginning in mediation. Like my first thing that when I welcome them to our office, it's like, here's a list of documents I will be requesting. If there's anything missing, we will put you on task to keep digging for those documents that both parties want to review or have access to. Because in this process, whether it's litigated or mediation, both parties have the right to transparency and full disclosure. So whether you're doing it through mediation or through your mediators or through your trusted attorney who's you know um, you know uh, advocating for you on your behalf, that's a huge part of the process. um, so you mentioned before premarital and marital assets. Can you describe, or separate assets, can you guys describe what that means to somebody?
Yes, essentially, I use the date of marriage as the line. So from I do until I don't. The date of marriage until the date of getting divorced is the body of work, which is called marital. Premarital, obviously, is before the marriage, and so the court can exempt out or keep separate anything that was premarital in nature. In certain situations, the court can consider the increased appreciation in value in a premarital asset if it increased in value during the marriage due to the efforts of either of the parties, not just one or the other, but efforts of the parties. And so you get to this whole analysis of what was done to increase the value. Was it maintenance? Was it repairs? Was it renovations? Is it something that increased the value through an addition on the house or roofing the house? The court will segregate out many times what was done in the ordinary course simply to maintain the value. That may not be what contributes to the increased appreciation of value. So that is one segment that, although premarital is non-marital, that increased appreciation can be counted. So it's very important, and this is where Jane comes in once again, is what do the statements show? Bring us what things show the value were at the date of marriage. Money is money, so if money is kept separate, it's not commingled, it's not mixed together. Oftentimes, the court will exclude that as non-marital. But in a happy marriage, which everyone starts out with the goal of a happy marriage, many things are commingled, they are mixed together, and therefore that becomes marital. So premarital and marital, separate and marital. It's a task of sorting it all out. And paper helps out. If everyone knew on the date of their marriage they should save all their paper, then I suppose a divorce would be easier. But not
Yes.
everyone does that. And so once again, it's the fine art of managing emotions. This can be accomplished. This can be looked at. And yes, you may have been so good and so nice that you made it marital. Mediation, once again, helps do that on a more civil note. Instead of doing it in the anteroom at a courthouse where people's emotions are high and judges are waiting, that can be accomplished through mediators doing that with you.
Right. Well, I'm certainly not popular at this phase of my life at all of my friends' weddings when I'm saying, congratulations, please save copies of your 401ks and bank accounts if you intend
Yes.
to keep that separate at this point in time.
Right,
But
Good
that's what more
advice.
people should be
right.
doing.
That's
But
good
I mean,
advice.
Kari hits the kind of what I think is the biggest piece of this, which is the question of commingling, transmuting, taking these assets that may have been non-marital, premarital, and then all of a sudden they start to go into the pot and everything starts to get mixed together. And a lot of people may say, well, wait a minute, right? That was my bank account before we got married. Well, you put their name on it and you started to let everybody in, and all of a sudden that account now is possibly up for grabs. And so, really, the big expectation for a lot of people should be, which I don't think it is from the second you walk down the aisle and say I do to that person, they are your business partner, right? And everything that comes in is jointly together. And if they intend differently, well, a prenup could have protected that, but sometimes the damage, so to say, is done and you're stuck with it. And so I think, Kari, I know, shares this experience where we sometimes are just delivering bad news to clients, right? And saying, well, I understand that's may have not what you wanted to do, but that's what you did do. And there's not much that we can do to change it now. We can't rewrite assets. We can only take them as they lie.
We see so many cases. I mean, especially in the case of real estate, right? Like one party's parents gives them $100,000 towards the purchase of their house, and now that was technically a gift, and now they didn't have anything in writing saying that this is the parents' gift and that they would want it back in the event of divorce. So there's so many complicating factors that money can just get mixed in, and there might not be a chance that you might get a credit back for that.
Right.
um in mediation, sometimes we are successful in doing that, carving out a piece of what feels fair to both parties to say, okay, I know that this was we have we had a case in the past where the person owned the property prior to the marriage, right? A property, then sold it and had a prenup, sold it, purchased a new property during the marriage with their premarital assets. So technically that would be protected through the prenup and also through the deed of the house, which means there's only one person's name on the deed. So technically that would still be premarital property. However, this person took out a mortgage during the course of the marriage and then paid it back with marital assets. So then, of course, that commingles and transmutes that so-called premarital assets. So again, every situation's different, but I mean, those are some of the issues that we are working through in mediation to try to see what feels fair. All right, we got to
Right.
move
Well,
on.
and my personal
Oh, go
favorite
ahead.
and least favorite, though, I will say is the house owned individually that then during the marriage they want to put a HELOC on, and the bank
Hmm.
says, "Oh, we can't do it unless you put both names on the deed." And
Yep.
so they do that, and now something that was partially out is totally in.
Yep.
And what feels fair to individuals in the moment versus what the courts, the laws, and the statutes deem fair. I say to people, it's kind of like Alice in Wonderland through the looking glass, right? You have to suspend what you feel is fair and apply these other sets of rules that these systems have decided is fair.
Right.
If
Correct.
you can't agree in mediation.
Yep. Um, just highlighting some of the other areas, what might come up. I mean, when we're looking at the total asset division of who's getting which assets, and if people are trading off, as you know, real estate's a huge hot issue right now. It has been for a few years. It always has been, let's face it. But ever since interest rates have increased, obviously real estate's a huge roadblock for people, and how to navigate that, right? But talking about that, how to figure out, is there going to be a deferred sale of the property with a division of assets down the line to keep maybe minor kids in a school system that they've been used to? How do we, some of those questions really get difficult, where someone's now looking at a buyout of their spouse and it becomes completely unaffordable now that they have to refinance the existing mortgage at these higher rates and also increase their debt by a significant amount just because of the fact of the appreciation of the real estate. Um, we've had to get a little more creative I think you both would agree with me that we've had to get a little more creative on the real estate front, and people have to be more willing to contemplate, alternatives. What happens in the case when both spouses want to keep the house?
You ever seen bidding wars? That's
Yes.
essentially what it turns into, right? Like,
Yeah.
I've had judges say, all right, everybody write down what the highest number they're willing to and can qualify for, right? Like,
Hmm.
what are they willing to sacrifice in other assets if they exist to do it? I mean, they certainly exist. I will say in the last, several years, Jane, as you indicated, I'm seeing less and less of bidding wars between parties. And I'm seeing more of people saying, well, I don't want to agree to a deferred sale, but I want, keep the kids in the house. How do I get my money now? And the judges, in many cases, are kind of shrugging and saying, if you can't work something out, my only power is to sell the house. And so, some people that treat it as a very contentious opportunity when faced with the reality of, well, if it gets sold, my kids can't stay in district, or, they lose that stability. It kind of forces people into getting creative with deferred sales. And
Yeah.
I know, Jane, with your assistance, we've done some where, we apply interest over time, on a calculation. So that way
Mhm.
somebody's not getting, screwed out of additional equity that they may
Yeah.
be entitled to over time. So it's a fascinating area that, again, if people are willing to be creative and flexible, there can be workarounds. But if there's not, the court's been rather cold to that issue, which
Mm.
they only have so many tools at their disposal. So I understand it, but it's not a reality that many folks like.
So in mediation, what we work on is getting the both parties to say, if I was in, what would it be? If I was out, what would it be? Oftentimes people look at towards a perspective of simply what they want, with them being the victor. It won't work out that way. It shouldn't be fair. So I always use the analogy that the home has become a college dormitory. It's where your children live. Who's in is the RA, and who's out, who with the children going back and forth. But there's a fair market rental value of everything. So if mom is leaving the home and she has to pay $3,000 a month to rent, then we have to look at that and bring some balance to it. If dad is leaving, then what's the value of that? All with the stated goal of they're both giving up something if they truly want what's best for their children, and that's keeping them in the home. I always look at it like, let's try and keep this house. How can it work? But you have to look at it for fairness from the other side, the exiting party. And unless people are willing to do that, yes, door number one is always sell the house and split the money. And that's not what's always best for mother, father, or the children. And
Especially
deferred,
today,
yes.
Right.
So,
where
but the
there's
court
limited
will,
housing.
right. So how can this be equally fair? If you were out, what would you want it to be? Because one would be out and one would be in. But as
Hmm.
Victoria said, the default is sell and split. So knowing that, why would people ever go to court, spend tens of thousands of dollars on attorneys, only to get an answer that's dark? They should
Mm.
be working together to try and resolve it through.
Yeah.
Right.
Yep. And again, we're talking about this, but that totally directly ties into other areas, right? Like liquidity. And if someone's keeping the house, and are they giving up other liquid assets in exchange for that? And that's really where I kind of help balance the scales of, look, this is what you're asking for, but A, can you afford it based on your income and potential cash flow now, and also when your child support ends or when your spousal support ends, is that still going to be a realistic thing for you? Or are you going to have to make a tougher decision, like, yes, at some point in time you are going to be selling this real estate? All fascinating stuff. And again, that also ties back to standard of living, and it ties back to spousal support as well. Like if someone's leaving the house, or if someone is um you know, staying in the house, what will they need to support that? Right. So
Right.
it's a lot more detailed financial planning, so to speak, where that's my domain, is helping people with all the budgeting and cash flow, and talking about what feels reasonable, fair, and equitable in terms of support for amount and time frame. We'll get into that a little bit, and we're going to kind of move through these next segments a little faster because we're tight on time. But other complicating factors might be, like I mentioned, liquidity options. Are our assets actually divisible? Certain retirement accounts, certain annuities, certain investment options are not actually liquid at the point in time. So we need to figure out creatively, how are we going to offset or divide those at a later date? Taxation, if someone's owed a buyout of a house, but they're keeping retirement assets instead, those are not two equal assets, right? Retirement assets are always going to be taxed. A buyout of a house is cash, so we need to tax affect that scenario to make sure that that's fair and equitable. And again, this is my favorite area, but executive compensation, where it deals with restricted stock units, non-qualified stock options, um, those are not really divisible in every scenario. So those present complicating factors, and then also they vest over time. So if a parties are divorced, what portion of that is going to be marital?
I
I don't
think
know
for
if you
most people,
two.
when they hear those words, their stomach turns sour, but Jane
Yeah,
gets excited, and that's what we love about her,
I
right?
love it.
Because
I love it.
it's a quagmire, and it runs into, as you raise, okay, stocks are going to get divided, right? If you're doing it in kind, there's different tax implications than if they're selling and liquidating, and then who's going to bear that going forward? And these are all considerations that make a huge difference given the values that are typically at play. And so
Yeah.
to kind of ignore and fluff those off, it can be a fatal mistake for many.
Yep. Two more avenues that I want to just discuss: dissipation of assets and tracing. Those are two things that I work on for people who have concerns about that. That also might be something that stalls your process to do that sort of tracing. I am not a forensic accountant, so I do not do more of the accounting stuff. I can do trace expenses on credit cards, bank accounts, things of that nature. But when it comes to tracing, like what people are running through their business books versus what the income has been, business owners are a whole nother deal, and that also can create a bigger stall in the process of divorce, because there might be a business valuation that needs to be done. Carrie and I are actually going to have a business valuation expert on one of our next podcasts to talk about that. But we could probably do a whole host, maybe that whole episode, Carrie, will just be on the complications of
Sure.
being involved with a business and divorce.
Right.
Right. And but not to minimize yourself, Jane, but what Jane does in the I don't want to say the average divorce, but everyone's case is significant to them, whether it's $200,000 or $200 million. But a lot of the conflict of marriages is in the trenches. What was spent during the marriage on credit cards, from savings accounts, etc. In that nucleus, that's in Jane's wheelhouse. Victoria, who we refer to and who does the litigation, will say that's where people should not spend an equal amount of money fighting about those statements with lawyers reviewing them. They should have a tracer like Jane doing that. Yes, at the high level business where people haven't been keeping their eyes on it for years or simply don't know, that's where a forensic account's needed. But the forensic accountant will be the first to say that the work that Jane does, they don't do. And yes, the work that Jane does, they might not do. But
Yep.
on your traditional Rhode Island divorce, if you will, with assets of anywhere between $0 and $2 to $3 million within the marital business, if you will, that's where tracing by Jane is important. And lawyers will agree that lawyers are not qualified to do that. What
Right.
Jane does is believe it or not, hasn't been done for decades, but it's being done now. Is, as Jane says, I love numbers, and so the lawyers run away from numbers, and lawyers rely upon what people say, but the statements don't lie. The statements tell the tale, and once that's done as a tool by an attorney like Victoria in the litigation role, or myself in the mediation role, when it's all on the table, I think when confronted with the numbers or presented with the numbers, because mediation is more presentation than confrontation, people come to the middle, and that's where they
Right.
should be, because it's all about the delta. Victoria and I will agree. Why would you spend $100,000 fighting about $100,000? Why would you
Right.
take another year of your life causing distress and disdain when the numbers tell the tale? And
Or even
so,
worse, why are we spending $100,000 to fight about $50,000,
right,
right?
Hmm.
And
right,
that's where, identifying the appropriate tool for the task in front of you is important, right?
right,
Just because a spouse may have a business doesn't necessarily mean you might need a huge forensic business evaluation that's going to cost more than it's worth. And I've had those cautionary tales where I've had individuals that are so convinced that there's this big gold nugget sitting at the bottom. And I've said, well, this isn't tracking and this isn't showing. And are you sure? Are you
right,
sure? And they spend more than what it's worth at the end of the day. And just because
Hmm.
you've invested that, doesn't mean you get it out if the asset doesn't exist like that.
Right.
True.
Right.
True.
10% of
Yes.
people will always fight. 10% of people will always do the litigation route. 10% of people will spend all their money on lawyers in conflict. But the optimistic viewpoint of that is I firmly believe 90% of people want to get to the middle. They want to
Right.
resolve it. They want it to be a satisfied result to both. Their emotions might be getting in the way at the time, but in the bigger picture, there's cars to be paid for, mortgages to be paid for, college tuitions to be paid for. Add that number up and invest your money in that as opposed to investing it in attorneys that will
Right.
accomplish nothing. Because I think we can all agree 5 years later, people always remember how much they spent on their lawyers. They don't remember how much they recaptured. They don't remember exactly if it was a good result or not, but they certainly remember how much they spent on lawyers. In the mediation process, we're working with myself and Jane and Victoria on the other end, giving legal advice. We don't give legal advice. Victoria gives legal advice. We give information. But with that whole circle working in that support network, it serves everybody's interest better. Everyone has people watching this podcast should consider that it's not about how am I going to defeat, how am I going to conquer. It's going to be how am I fairly going to get to the middle. And both
How am I
sides should
going to
look at that.
compromise?
Both
Right.
sides
Because,
should look at that.
and I tell my clients all the time, in those situations, sometimes the only person that's making out is me. And I don't sleep well at night in those cases. And I'm, often having those conversations with my clients saying, you are going to pay more than you are going to get. This is not a good use of your time and money. Keep it in your pocket. Put it towards your children. Don't put it towards my children and my future.
Right.
That's why we love working with you, because you tell it like it is and you give people real honest advice and feedback as an attorney. So that's great. Managing expectations of clients is the hardest part of this job. We were just talking about it as we jumped on. But all right, so moving on to child custody. This is not my domain, and it actually scares me to death because when I went through my own divorce, it was like the biggest pain point for me. But we happen to manage that very well, my ex-husband and I. So, what are some of the issues with custody that you see, and just give us a peek behind that?
So, I mean, and this is where Kari and I make a great pair in this sense, because I come at it from the litigation perspective, and Kari has the distinct honor of being one of our beloved guardian ad litems in the state of Rhode Island. For those not familiar, a guardian ad litem is an attorney that's typically appointed by the court that is there to investigate the best interests of the minor children and help to make recommendations to the court about what that best interest is and how it's best served when parties can't come together and reach that agreement on their own. Kids boil down to custody and placement, right? Custody is the right to make major life decisions, health, education, religion. I joke that unless you're like an axe murderer or like, actively molesting your own children, typically you're looking at a joint custody situation where you're making decisions for your children together equally with your spouse. Nobody wears the crown. Nobody has, the kind of veto power. And placement is really typically the big fight that people are having, where the children live, who are they visiting with, what that schedule looks like, what that timing looks like. That's normally where the big fight is had. And then, of course, child support rolls into that as well. And the reason why placement becomes such a big fight in Rhode Island is that child support is tied to placement. So whoever has primary placement is typically receiving support from the other parent. And traditionally it's with one parent or another, but we're seeing kind of a trend and a tracking more towards equal parenting time if parties are able to make that work, because equal time requires normally more interaction of parents. And for many folks getting divorced, that's the last thing they want to do is interact with their spouse at the same rate that they were when they were married.
I like to consider my present status in my practice of law as when you turn on the news and the expert that they're having narrating what just happened, it says former agent or former investigator. I'm former guardian ad litem, so I bring that life experience to this mediation process. Yes, guardian ad litems are great, but I go back to the 90-10. 10% of families will always be in conflict for 9 to 10 to 12, 13 years, watching the children grow up. They will be in court. They will need a guardian. I think more people after watching this podcast should realize they can accomplish what's best for their children in mediation. And then, yes, I bring that skill set of telling people how much time and how long it takes and what's investigated if you're the guardian. But you should invest in yourselves. Listen to this process where I, as a former guardian, working with Jane, who's gone through that experience, will tell you what's going to happen. There's all protocols. There's the case called Petnato versus Petnato that gives 8 factors that you look at. So you should be discussing those in mediation and working them through as opposed to litigating them at court. Some cases will need to be litigated. Some cases will need to be investigated. But at the end of the day, the parties that should be in mediation, they know their children best. The one thing that's going to happen is if 2 parties can't live together for the rest of their lives, it does not mean that they won't be sharing their children for the rest of their lives. My adage is you own them from 0 to 18 and they own you for a lifetime thereafter. How you handle it for those 18 years, sharing and caring and working together, will define when, how, and if you ever see your children again.
Yeah.
That might seem dark, but it's true. Everyone has a story of the kid they went to school with whose parents never got along, and ask them at age 30 or 40 what their perspective on it was. So if people are think of their children first, and then tangentially that'll expand out to them, the marital unit, the family unit can be preserved through mediation. Yes, get a guardian if you need it, but you don't need a guardian in this process. You have 2 qualified people that will manage that and then refer out to Victoria on that. All lawyers will tell you that it should be worked out by the parties before it's litigated with a guardian. That's the former guardian ad litem speaking in mediation.
Yeah, absolutely. And I would say that for many, many folks, it is that 10% that needs a guardian, right? You have to be a true high conflict, unable to see the light of day to work anything else where a guardian's coming into play. And it's a sad scenario, I will say, in many, many cases, because guardians can get clinicians involved and all these other professionals. And what I hear over and over and over and over again, I should, tattoo it on my forehead, which is, if only mom and dad could just pull it together in front of the kids, they would be okay, right?
Yeah.
If mom and dad could put it aside, or mom and mom, or dad and dad, if the parties, whoever it may be, if they can put it aside and just rein it in while they're in front of their kids for the benefit of their kids, the kids will be all right. And
I think the
it's
misperception is from some clients that, yes, I'm going to get sole custody and my ex-husband or my ex-wife, because they're so hostile and they're such a narcissist, that I'm going to get everything. Or even if they have like a drinking problem, or even if they're somewhat abusive emotionally, people automatically think I'm going to get full custody, and they try to fight and fight and fight to
right.
get that. And I mean, give the perspective what the court's view is on that.
Yeah, I mean, if there is a parent that is willing and wanting to see their children, and they are willing, if there is a drug problem, an alcohol
Mm,
problem, or something like that, but they're going through the steps to show that they're appropriate, they're trying, to clean themselves up and correct their behavior, there's always going to be an avenue where there is going to be some level of contact. And in those extreme situations where there is, I'll share, I did a case where there was severe felony level child abuse.
hmm
Straight up, an individual is sitting incarcerated because of child abuse that took place during the marriage. Even in that scenario, there was a path laid out in a final adjudication of the case that if parent who's incarcerated ever gets out, and if they go through certain counseling, and if the children's counseling say that it's appropriate and all this clear path, then they could still try to reunify, right? So from my perspective, I tell people, you're never done with this person, even in
mm,
the most extreme cases. So
yeah.
barring something like that, you're going to have to parent with them, you're going to see them, your children are going to see them. And I think we can all say children see both parents reflected in themselves.
Yeah.
So even in efforts where parents are trying to protect children from a dangerous situation, or what they perceive as a dangerous situation that may not necessarily be life threatening, they have to be careful that they're not turning the child away from the other parent and the parts of that parent that they see in themselves. And that's, where I'll go with that. But yeah, they're in it and they will be in it. And even after 18, as Kari says, there will be graduations, there will be weddings, there will be grandbabies, there will be all these things in life
hmm
that you're still going to be in it with
Yeah.
your ex-spouse.
Right.
All right. Final topic: support, child support, and spousal support. Can you guys just give our viewers or listeners the perspective from the Rhode Island court on what that looks like?
Sorry.
Well, child support is a calculation, blessedly. What it is it, well, and not blessedly, it takes into account individuals' gross, not net, monthly income, and it plugs it in, given certain factors and information in a state guideline that was come up with by individuals on a much higher pay grade than myself. And it delivers a number at the bottom that is based on a percentage of everybody's income of what should be paid to the children. The court typically sees that as a floor and not a ceiling. So some people get that number and go, oh boy, okay, that's the max that I could pay. Oh, no, no, friend. That's normally the minimum. If you're going a traditional litigation route, if you're in a mediation status, then there's certainly more flexibility and room around that. Alimony, spousal support, there is no traditional formalized calculation in the state of Rhode Island. I know some of our neighboring jurisdictions have been wise enough and kind enough to put a calculation in. We are not one of those. So there's factors that the court looks at. It is a sliding scale, so to say, and I found, and I'm sure Kari will confirm, it can be very judge dependent, right? So we have some judges that traditionally may be very anti alimony and spousal support given the circumstances, and we have some that maybe are a little bit more lenient and will apply the factors more generously than others.
Mhm.
So
Yeah,
that's
so
where
if
it
you
kind of
can't come,
sits.
yeah, if you can't come to an agreement, right, on the amount and length of spousal support, then that could be one of the factors that might hold you up. Part of what I do is the cash flow analysis, income analysis. What does the division of assets look like, and what does each party need to support themselves? It's not a one-sided thing. It's not the person who is maybe underemployed. We're not only thinking of them, we're thinking of both parties collectively as a unit, as a family. What is the collective income? And if one party is unemployed or underemployed, we have a path to where they need to get rehabilitated. I mean, it's rehabilitative in nature in the state of Rhode Island. So we have to try to get a path to rehabilitation where they're financially independent and self supporting.
Right.
Right. So,
Rehabilitative is a not forever, right? It's to get them
yeah.
back on their feet, back in the workforce, back
Yeah.
to being self sufficient, not
Yeah.
just here
So
it is,
it's
have a
it's
nice day.
typically, I mean, it's a short-term time frame. It doesn't even matter if like we've come up against 35-year marriages, and the spousal support's like pretty short term, right?
Yeah.
The other factor that we look at is, if one party's, like, say both parties are retired and someone's been underemployed, and they're maybe younger than the retired spouse who was the breadwinner. We could look at the division of assets in a different way. Maybe not, it's not 50-50. Maybe it's an offset somewhere, 55-45, 60-40, depending on, the factors that Victoria mentioned. It's like health, station in life, contributions to the marriage, employability of the parties. What am I missing?
Educational background, job
Educational
skills,
background.
job training, the
Yeah,
need of one, the ability of the other. I mean, it's a
yeah,
multi-factored piece.
yeah. So this is an art, not a science. It's really where there's a lot of negotiating that happens. There's a lot of back and forth on this topic of spousal support. Um, but hopefully, I can lend some credence and some background as to why this may work or not work for both parties, right? Depending on how the agreements are going.
Right. And I mean, something the court does, and you raised Jane, look at is what are the assets that people are taking from the marriage or leaving the marriage with, right? So, somebody who may not have a, job experience, work experience, but they're taking half the assets, but they're the beneficiary of a trust that's not subject for division, right? A court may look very differently on that individual compared to somebody who is only taking the assets, that they have of their marriage, and they've never worked a job and they have no skills. So it truly is so situational dependent.
Yeah.
I forewarn my clients though that Rhode Island traditionally and typically is not an alimony or spousal
Mhm.
support friendly state that you will
Yeah.
be expected to stand on your own feet rapidly. And
Yep.
so that's something for many folks to be aware of.
Yeah. We do a lot of career coaching, thinking about next chapters, next steps. It's all part of our conversations. It's all good stuff.
My short perspective on that is every marital unit knows more what's going on in their lives than the judge will, the lawyers will, even the mediators will. So, although people might resist the concept of support because it's the word alimony, is It's a body of work. It's a package. If you, depending on how long you've been married, alimony considerations are probably coming into play with a more long-term marriage, 10 to 20 years, maybe 5 to 10, maybe 5 to 15. But nonetheless, if there's a need for support of one or the other, it's right in front of the parties. They already know it. They know that whether they even agree upon why mom stayed home or dad stayed home, they stayed home and no one did anything about it. So now it's a matter of rehabilitating, a word that we don't like, but it's what the law says, someone back into the workforce. Everyone needs to know that unless they're much older, they will be rehabilitated back into the workforce. So I always come back to, do you want to spend it on lawyers or do you want to invest it into the equation in the mediation? If the delta is 50,000, 100,000, whatever it is, that's potential alimony, why are you spending it on lawyers to rebuff it or seek it when you could be investing it from the marital pot of the value? The facts won't go away. A judge will consider those issues. If you've been married a short-term marriage, that's not an alimony case. But if you have not been in the workforce, or you've left skills that you had that have to be redeveloped, the court will consider all that. And both parties should sit in the mediation setting and consider all that. Once again, in this circle of Victoria giving that advice or legal information, in a mediation setting, it can be resolved. If the delta is $1 million, then that's not going to be easily resolved. But Jane and I have a case right now with a person seeking that large of a delta difference. After speaking with lawyers, they were told they're not going to accomplish that. So returning back to the mediation table to reallocate, is it assets? It doesn't always have to be a payment. It can be the shifting certain assets now so that one person is not paying later.
Or
In short,
covering,
right.
oh,
What's
I was
that?
going to say, or covering healthcare as part of the support package, or covering the car payment that was run through the business for all the years, and the cell phone payments. Like, we look at this holistically from a big picture and try to quantify all the benefits that they've agreed to wrap that into sort of a spousal support package.
Right.
Let's
Well, and
say,
there's the
how much
short.
is it going to cost and how am I going to make out? The how am I going to make out should be a mutual decision. What's fair to both so that with children or without children, they feel that they handled it fairly. If people don't want to handle it fairly and they want to litigate it, ultimately at the other end, their assessment will still be, wow, I spent a lot of time and a lot of money. And what did I really get out of it? If you end up paying the $50,000, but it cost you $50,000, it really cost you $100,000.
Yeah.
And so the facts are right in front of the parties at all times. The best way is to mediate.
Right. Right.
All right. So, parting words, guys, we've got to wrap this up. You guys have been great. Thank you for all of your pearls of wisdom from the battlefield. All right. So, when we're talking to clients about like do's and don'ts, what are the first things that come to your mind? Let's start with the do's.
Do be prepared, right? Do your homework. If you are watching these videos, you have already started your homework. So good job. Do be organized, right? Don't come with shoeboxes of paper crumpled up saying, "Ah, here you go."
We've gotten that a few times.
We have, but not ideal. And I would say do be willing to be flexible. I mean, there are no winners in family court. I think every practitioner in family court, every judge, every clerk, every sheriff, anybody who stands in that room all day will be the first to say there are no winners, right? There are only losers, so to say, in that sense. And so to be willing and open to come to these processes to discuss and find common ground and find concessions and agreements, it's the only way to do it.
Invest in the settlement of your case. Do mediate. Do get legal advice from Victoria to find out exactly that mediation is not hocus pocus. It's not some rare science. It's the fine art of getting two people in the same room at the same time, hashing out the issues, coming up with potential resolutions, and do bounce that then off your attorney. Do not spend $50,000, $60,000, $70,000 on attorney fees on your divorce. Do seek mediation and spend your money wisely in having qualified mediators, tracers, investment persons filling out the forms, and then going to Victoria and her firm to have an uncontested nominal divorce that you both can live with.
Yep.
Right.
I agree. I would only add to that maybe as you're thinking about this to prioritize your needs and wants, right? So think about what's most important to you. Think about the what ifs. And again, we as attorneys and financial advisors, divorce in this divorce space, we're helping clients trying to identify that. What is scenario A, B, and C? What is your main goal out of this? It can't be everything because, again, this is a negotiation. This is the biggest negotiation of your life. So you have to be willing to concede on some things. You have to be willing to wiggle some things around and maybe not get all of what you wanted, but you need to know what's most important to you and what your priorities are. But
Right.
all of that is great stuff. And I would
And I
say
would add to
don't,
that your needs and wants, but the needs and wants of your children too, right?
oh,
So,
1000%. If you can put
that
your
may look
kids'
different.
needs first, your path becomes a lot easier to try to navigate. I agree. I think that if you're really truly thinking about your children and what's best for them, then your decisions will be easy from there. Not so easy, not without conflict, but what you need to do will be easier to figure out.
Right.
All right, any parting words or are we good?
And no, I mean, thank you so much for having me and for the time and for doing this and all the work that both you and Kari do. I mean, you are a huge asset and testament to our industry and the time that you take to get these folks through this process without World War III and at such a huge expense. So thank you, seriously.
Thank you so much. Thank
You,
you. We love
Victoria.
partnering with you guys and you ladies. And thank you so much, folks. You can check out the full version of this on our, I think it's going to be on YouTube, on our YouTube channel. But thank you for joining the Better Divorce podcast. This is episode 3. We'll have episode 4 and 5 coming. We're going to be talking about high conflict cases and personality disorders and how that can play into the mix. And we're also going to do a segment on business valuations, taxation, with some other special guests. So thank you for joining us today. And thank you, Victoria, for joining us.
Thank
Thank
you.
you.